attorney in Torrance and specializes in elder law with over 25 years of experience in estate planning, probate, and special needs trust. And best of all, her expertise includes planning for public benefit programs such as SSI and Medi-Cal. So I think what she's going to do is give us some words of wisdom and then leave time for questions and answers later if you have them. So please welcome Cynthia.
Thank you, everyone. Thank you so much. First of all, what a lovely, lovely service. And I really was coveting your tenor. I wanted to bring him home with me. What a fantastic voice he has. It's lovely. Absolutely lovely. Bring you greetings from St. Andrew's Presbyterian Church. I started going there about 20 years ago. I ended up marrying as a second marriage Tom Cox. His father was the pastor of that church for over 35 years. So we have Presbyterian roots going back quite a long ways. So thrilled to be here. Absolutely thrilled to be here. A little bit about myself. I went to Loyola Law School, and I wanted to do elder law from the very moment that I contemplated law. I was one of those folks who gravitated towards everyone that had gone through World War II, our greatest generation, and absolutely loved that area of the law from the very beginning. And then that grew into an outgrowth of special needs trusts as well, because to serve that group properly, I needed to know convalescent planning, Medi-Cal planning, and then that grew into SSI, which also grew into special needs trusts. So my office has 2 other attorneys and 6 other members, 4 paralegals, myself. So we're kind of a little boutique firm that we've been doing this quite a long time, over 30 years. Actually, now I need to update that. So over 30 years I've been doing this practice, and I absolutely love it. Every day get out of bed and I'm excited about what we can do for this day. And we also do conservatorship work, which is full of drama right now due to all of the situation around Britney Spears and that sort of circumstance. So as far as my presentation goes, for those of you who are at home, I did bring some materials. Hopefully we can turn these into a PDF and I can send those to you so that can be shared with you also. This is really a situation where I'm going to just touch on things that add about 30,000 feet, because in an hour I can't possibly educate you on all of the nuances of things. And I want to leave plenty of time for questions and for concerns. Because it's a presentation that's on the internet here, I think I need to go through a little bit and ask the questions at the end. If it were just this small group, I would have those questions interjected, but I think it's too disjointed for the folks at home. So I'm going to just go through, and then I inadvertently but possibly kindly included a whole blank sheet of paper in page 2. So if you have, you can jot down your questions as they go. I provided you with that. I'll put on my glasses here. Of course, we're in a charitable institution, so it goes without saying that we do some charitable planning, that we certainly talk about that and talk about honoring God from a gift from our church, from our trust as well. To let you know that one of the best ways to give is if you have an IRA and you want to benefit your church, you certainly can look at that as a way to do giving in a way that is tax intelligent. Because if you give that same IRA to a child or another family member, most of the time that will have to be paid and taxed, because it's before tax dollars. So if you give that money or a portion of that money to a charity, you can actually designate the IRA as part of your charitable donation. So that's just a little tip. Or you can donate life insurance and things like that. So talking about certain strategies about estate planning. I'm going to just discuss avoiding a probate and talking about trust, just briefly. I think most people have heard this in California. Now I'm on paragraph D in our outline, which would be your page 3. So in most cases, any time that you have more than a probate amount, you're going to be wanting to look at avoiding probate in California. You wanted to avoid it before the pandemic hit. Now you want to avoid it even more because the court system is in a complete disaster. We have about a 2-year waiting period to get people through probate at this point in time because we have so many delays in filings because the court has been impacted with its employees, just like the other folks, the Jiffy Lubes and the restaurants and every other place that you go where you're now finding inordinate waiting. You're certainly going to find that in the court system. The unfortunate part about having the court system so impacted is that there are people who really need emergency assistance, and often they can't get that assistance that's needed in the court system. So you want to avoid probate, and the magic number now is $166,250. And that is not equity that we're talking about. Those are gross numbers. So if you have a home and that home is not passing by joint tenancy or transfer on death, all of which have kind of problems with doing it that way, you'll need to put that home in a living trust and avoid probate entirely. If you have an investment that's $200,000 and you haven't designated a beneficiary on it or transfer on death, which again, those are problematic, or joint tenancy, then you need to be looking at putting that into a trust and transferring it in that way. There are a lot of really competent, really good attorneys who do trust work in Los Angeles County. It is an expense that's well worth it, because if you calculate the amount that someone would receive, an attorney and your executor, in probating your estate, your calculation is going to basically be 4% of the first $100,000 worth of value, 3% of the next $100,000, so now you're already at $7,000 worth of fees on a $200,000 estate, and then 2% of the next $800,000, so now you're at $23,000 for the first million. And we're not even talking about whether you owe an obligation on that. So let's say you have $1 million home and you have $900,000 that you owe on that home. You're still going to pay $23,000 in probate fees because it's irrespective of anything that's owed on the property. They gross it up, and then that's the fee that's paid to the attorney, and that's also the fee that is paid to your executor unless they waive that. We're not even into or talking about the built-in costs of probate as well. So every filing fee in Los Angeles County now, you'll be hit with somewhere around $500, $490 for every filing, unless it's related to special needs or something like that. And so that filing fee happens. You have to pay the probate referee a percentage to value the assets. You have to pay a bonding company to insure, because most of the time the courts are resistant to waiving bonds. One time I represented the Little Sisters of the Poor, and surprisingly, they didn't have any assets. So it was very hard to get them bonded, but the court still insisted that the Little Sisters of the Poor had to be bonded. And so that was a little crazy. So just to let you know that the propensity is to get to bond everything. Yeah, so that's another expense. So you're generally looking at $4,000 plus or minus, maybe a little more, just for pure costs in a probate situation. Not to mention the fact that there can be extraordinary fees that are given to the attorney as well. And the extraordinary fees are not extraordinary things. So an attorney gets to charge their hourly rate for anything related to taxation. Well, all estates have tax issues, right? So there's a little bit of extraordinary fees. Any sale of real property, an attorney can charge extraordinary fees. So those sorts of things. So I think I've convinced you to try and avoid probate, right? And most of you probably have living trusts, and kudos to you. Thank you for doing that. All right, so you also want to be mindful of what's happening with the estate tax. Right now, there is an $11.8 million exemption per person for estate taxes, which is tantamount for most people to it basically being repealed, because most of us are under $11,800,000 in our tax situation. The Biden administration is looking at rolling this back to either $5 million or $3.5 million. I can't tell you how many times in my 30 years of practice this has changed. I've gone through a $600,000 exemption. My predecessors right before that had only a $60,000 exemption. So we went all the way from a $600,000 exemption up to $1 million, up to $5 million. We had total repeal for a moment, and then we went back to a $10 million exemption adjusted by cost of living increase, and a lot of other things in between. And it does wax and wane with politics. So you also have to be mindful that if you are a married couple, or if you're not married and you're thinking that you might want to get married for tax reasons, you might want to consider it when the exemption goes back to $3.5 million and you're sitting there with $7 million. Also, if you are quite affluent, you definitely want to be talking to your estate planning attorney about the possibility of preserving some of this exclusion now, this $11.8 million. So let's say you had $40 million and your children were doing lovely and you really loved them and you wanted to give them a $10 million gift. Well, this is the year to do it, because now you're using that $11.8 million exemption. You're getting that all out estate tax free. So this is some of the things. We don't do very high-end, very sophisticated estate planning, but I have lots of dear friends who do that work and do it very, very well. So those are some of the things that you might want to consider. Going on to paragraph E, we want to talk a little bit about an area near and dear to my heart, and that is powers of attorney for financial matters. This is a basic, and often you'll see that this is left out of the estate plan entirely, that sometimes people will do a trust for you, they'll do a pour over will, but there's no power of attorney allowing someone to do your business for you should you become incapacitated. And what ends up happening if you have that gap is you have your trust and someone's managing your trust, but everything that's outside of your trust cannot be effectively managed. So your income stream is outside of the trust. The person who's going to sign your tax returns, that's outside of the trust. If you have a pension coming in and you have to manage that, that's outside of the trust. If you have assets or a business that needs to be run or whatever is happening, the power of attorney for financial matters is going to govern that. And often we'll have people that truly, this is a very inexpensive document. I've seen people prepare it from anywhere from $75 to $250 for that particular document, or maybe a little north of that. And it completely avoids a conservatorship if you get the right person in the driver's seat to be your agent. Now, choosing that person is very similar to choosing a trusted trustee, and that is you must have someone who has absolute integrity. You do not want to name people in birth order and things like that. And we'll talk about that a little later, choosing your agents, because choosing the people that can actually do things for you is one of the most important parts of the puzzle. But once you have that trusted agent in place, that person can then take up and start paying your bills and doing your business for you, and can fill in that gap so that no one need run off to court and start temporary conservatorship proceedings and the difficulty and embarrassment of declaring someone incapacitated and then having to go through that very expensive process. Because what happens with conservatorship, it becomes a living probate all during your lifetime. So you are conserved, and then unless you can be proven to be rehabilitated, that will continue throughout your entire life expectancy. You will be before the court the whole time. That person that becomes your conservator will have to file accountings, will have to be before the court. And these are the files that become boxes, that get into some enormous expense for just not attending to that very simple matter. Now, with powers of attorney, people don't always know that they can be either immediate or they can be springing powers of attorney. And attorneys have their own bias. And sometimes you won't be presented with all of the options because an attorney is quite biased on what they like or what they don't like. So you need to be aware of these things so you can ask these questions and know what you prefer when you go in. So about 50% of the attorneys will say, I prefer immediate powers of attorney, or I prefer springing powers of attorney. An immediate power of attorney puts someone in charge of your paying of your bills and so on right away, and without need of trigger. And so you as the principal are still paying your bills and doing your business, and someone else can jump in and pay your bills and do your business. And then you go back to paying your bills and doing your business. It's quite convenient for these situations where things wax and wane, where you've had some illness and now you're better, and maybe you've had some illness and now you're better. It's certainly advantageous from that standpoint. It's also advantageous from the standpoint that you don't have to prove incapacity for someone to be able to act, because in a springing power of attorney, that person is only triggered when you're incapacitated. And there's usually a trigger that says a doctor's letter and my agent sign a declaration under penalty of perjury that I can no longer act. And now that's triggered. And then your agent from that point forward can act. And toggling back and forth is a little more cumbersome. So you, under that document, your child or other trusted person would have to present that doctor's letters or those doctor's letters to your banking institution before they would be able to act. And sometimes it makes the banks and others a little more nervous because they want to make sure that the situation is really triggered and that sort of thing. So a lot of it also depends on your family dynamics. If you have a trusted son or daughter that doesn't have any financial issues, has a very solid spouse, and you're not worried whatsoever about when that would be triggered or if it would be triggered too early or those kinds of things, you might be better served to have an immediate power of attorney. If you had to name a remote cousin and you don't want to bother them with the situation until it's absolutely necessary, you might be better served to do a springing power of attorney. So, does that make sense? Okay. Powers of attorney for, I just want to touch on, there are certain powers in a financial power of attorney that are not there unless they are placed there intentionally. One of those powers is a power to do any kind of Medi-Cal planning. So if you were concerned about going into convalescent care and concerned that that might cause your entire estate to be eaten up by the costs of care, you could include some Medi-Cal planning in there. A lot of Medi-Cal planning involves shifting of assets by definition, because most long-term care Medi-Cal planning means that you have to be quite low in your assets. And so you can't give someone the ability to make gifts or do things like that unless you specify it in the document specifically. And you can imagine why. If you gave me a power of attorney and you said, oh, and by the way, Cynthia can make gifts to herself and self-deal, that would be a little weird. So the law wants you to specify those things. And there are certain other things like getting access to safe deposit boxes, some other things that really need to be specified. Interacting with a trust is also something that needs to be specified. And this is why it's so important to do a comprehensive estate plan where you have your trust, you have your powers of attorney, they're talking to one another. Because if they don't talk to each other, then you can't do what one of the documents or the other of the documents says. So if, for example, your power of attorney over here says, I allow Medi-Cal planning, I allow gifts to be made, I allow other things to happen, but your trust says, the powers to revoke or amend are exclusive to me and me alone, and nobody else can ever get into this trust, the agent under this power of attorney cannot access trust assets in order to make the gifts that you contemplated. So these things have to be done in tandem. It has to be thought through properly, and they have to be connected to one another in order for it to work. Powers to change beneficiaries, power to amend your trust. Sometimes you'll see that in your powers of attorney as well. Those are sensitive as obviously because it's the same sort of thing as making gifts. Sometimes it makes sense for the person, sometimes it doesn't. It just has to be analyzed on a case-by-case basis. Okay? Powers of attorney for health care are extremely important. I have samples, by the way, of a statutory form power of attorney for financial matters and for health care that are attached to this outline. Let's go to that just for a minute here. So this uniform statutory form power of attorney is one type of power of attorney that people can draft for you. This power of attorney allows your agent, if you initial all of the powers listed above, to do most things for you, but not those fancy things we were talking about. Your agent cannot amend your trust. They can't change beneficiary designations. They can't make gifts to themselves. But this sort of document will get most people through if they don't have the need to do precise or sophisticated planning of some sort. So there are two types of powers of attorney that you'll generally see. One is this statutory power of attorney, and it'll be mostly in this format, but an attorney will add language to this. Once in a while, you'll see a power of attorney where the attorney has drafted it himself or herself from the very beginning, and there won't be any of this statutory language. And they'll set forth every single power that they can think of. And so that will be your 36-page long sort of documents that you see. There are benefits and burdens to both sides. The statutory form power of attorney has some teeth to it. In other words, if you look at Probate Code 4401, it will say if this power of attorney is in this particular format, then this power of attorney will be honored by third parties. And so if I take this to a bank, they must honor it. And if they don't, and we have to go to court to compel the third party to honor it, then they have to pay our attorney's fees. And so that's one lovely thing about the statutory form power of attorney, because the other kind of power of attorney can be legitimately and legally ignored in a way. So the bank can say, I'm simply not comfortable with that power of attorney. We are in charge of making sure that people aren't abused in some way. We're worried about elder abuse. We're mandatory reporters, and this power of attorney is too old, or it's it's got some anomalies, or the signature looks too weak, or whatever the situation is, where the third party is going to say, we're just not comfortable with this. And in that case, you would have to go to court, and you would have to incur your own expense in order for it to be validated. The power of attorney that's longer, you can utilize that sort of power of attorney, but think about third parties and how they might look at that. And make sure that you keep them updated, because often what a bank or other third party will say is, we would be comfortable with this power of attorney, but it's too stale. It was signed 7 years ago, and a lot can change in 7 years. So maybe when you go in and do little amendments or little changes to your trust, think about just re-executing that same power of attorney, just so that you have something that's not stale, because most attorneys have those on their, their ongoing computer and that sort of thing, so it's not that difficult. Let's talk about the Advanced Healthcare Directive, because this is a very important document, because just like the power of attorney for financial matters, there is a gap when you cannot speak for yourself from a health standpoint. And so it becomes very important for you to sign something that does a lot of different things. First of all, there is, in general, an American Medical Association mandated choice about how you feel about life support. And again, these forms can vary dramatically. This is just my particular format. There are people that also draft these at 36 pages long and that sort of thing. But in any event, the first area that I would talk to you about is on page 4 of that document that is an appendix. And the two choices are choice not to prolong life or choice to prolong life. And these are, again, American Medical Association standard languages that you could debate until the cows come home about what does this mean, right? So this says, I don't want my life prolonged if I have an incurable, irreversible condition that will result in my death within a relatively short period of time, or I become unconscious to a reasonable degree of medical certainty, will not regain consciousness, or where the burdens outweigh the expected benefits. So it's like the old adage, hopefully, what is obscenity? Well, I have no idea how to define it, but I know it when I see it. It's kind of like that sort of situation, that you don't know how to define it, but you know it when you see it. When someone is suffering and they've been through a course of antibiotics, and the antibiotics make them very, very sick, and then the minute that they're off the antibiotics, the infection comes right back. They try a different kind of antibiotics, and the person's 95. And you know that this is suffering that is not potentially necessary or advantageous. That's the burdens outweigh the expected benefits, or the treatment outweighs the expected benefits, right? I've had people try to fashion these documents with every possible contingency, mostly engineers, right? And I love engineers. I was married to an engineer. All right, but just wanted to make that a good record. But somebody who wants to control these things, either from the grave or from a position of sickness, where if I have been on the respirator for 3.5 days and I'm still gasping for breath, go ahead and tailor it back a little bit and see how I do. 0.25. It doesn't really work, because you can't anticipate every potential circumstance. You simply can't. And so once you start doing that, you're like Alice in Wonderland. You go down the rabbit hole of, well, what if this? What if that? What if this? What if that? The other extreme is my father, the colonel in the Air Force, who says, well, the minute I have a cough and you can't resolve it, put me on an ice floe and push me out there just like the Eskimos. That doesn't work either. Terminate it and get it over with. Because you have to really understand that life and what we feel about how we want to live changes dramatically as we age. When you're in your 30s, you think, she's not going to have any quality of life. She's been brain dead too long, right? So these are one of these convert everyone in the Rosecrans Convalescent Hospital from that point forward. And so she had a wonderful time witnessing to everybody that she could find and wheeling out onto the street and talking to people. That's quality of life, right? As far as I can see. So, just know that those things are different for everyone. And I don't really recommend the 5 Wishes program necessarily for, I'll tell you what this is. This is kind of an interesting program. We all went through this when we were baby lawyers. And it was very interesting because it's an Aging with Dignity program where they talk about life expectancy and they talk about end-of-life decisions, and they talk about these things quite in depth. So this is a power of attorney that's very touchy-feely. So you go through it, and it says, I want to have my favorite music played at all times. I want to be massaged with warm oil. I wish my family and friends to know that I love them. I wish to be forgiven for the times I've hurt my family. Yeah, absolutely, that would work. So the nice thing, and I brought a stack of these, so anyone who wants one can have one. This, I think, more than a legal document, fosters the conversation that has to happen with your loved ones. And it's so important because I've had so many people tell me, you encouraged me to have that conversation with my loved one. And when my mom hit the floor, I heard her in my head saying, honey, if this ever happens, please do not call the paramedics. I've had this heart condition for so many years. And she said, but for us having that conversation, she would have been resuscitated and it would not have been what she wanted. So these are such important conversations to have with your family, to give them a sense of direction and also to give that person permission. And then to think through, what person would I really name on this document? And do they have my same value system? Do they have my same interests at heart? Would they be tough enough to do what I wanted? Or would they be gentle or too tough and just trip over the plug the minute they could? You don't want that either. So you just want to be careful about who you name, right? But these are really good conversations to have, and it really is helpful. So that I would commend to you. Then the other thing on the healthcare power of attorney is you make this statement of how you feel about life support in general. And I would recommend, if you look at box 1.3 on page 3, I would always recommend that you make these powers of attorney immediate, because this takes the guesswork out of the physician's hands of having to say, gee, can this person make a decision or can they not? Because as you know, a capacity determination, particularly in medical circumstances or in extreme emergency circumstances, is very hard for someone to call. It's very hard for someone to figure out. And then pretend that you're the agent over here and the power of attorney has not triggered yet, and you're trying to get the private medical information that you're allowed under this document to make a decision about whether the person has capacity or not. You can imagine you're now in Dorothy land, right? Where you can't get the information that you need because of HIPAA and those other things to be able to make an adequate decision. So I would think that making this effective immediately, there's no physician on earth that's going to take your daughter's word for it or your son's word for it that you need a major operation when he or she can look you in the eye and say, let me talk to you about this operation. Do you need this major operation? So you're not going to, I've never in 30 years seen anyone who signed this get into a big wrangle with their agent over whether something should happen or not. But in a circumstance where you need this to be effective because of emergencies, I would do that. And then thinking about who you want to name as your agent. This is very, very important. I had a gentleman one time whose wife was a Jehovah's Witness. And he said, she can make this call for me, but if she declines a blood transfusion, that's where she's out, and we're going to agent number 2 because I want them to be able to make that determination, you know. So thinking through the temperament, again, I can't emphasize enough, don't just put your children in birth order without thinking about their temperament, their propensity, their knowledge base. Would they be really good advocates for you, or are they folks that just go with the flow? Because you need a really good advocate. As Ms. Tan and I were talking this morning, it's essential to have a good advocate and a really strong advocate to help you make decisions and determinations. So, and then on these documents, you can name a primary physician. If you have a lovely physician, you can name, donate organs or parts and things like that. And then the very last page is the valid waiver so that the doctor can give your agent private medical information that's really necessary for them to be able to do their job. All right, so back up to the outline. The other thing that I just want to point out to you is that we have a post form. It's this wild pink form. This is not necessarily something that an attorney will create for you, but this replaced the old do not resuscitate forms. And so the power of attorney for health care is not necessarily the same as the do not resuscitate that's going to be hanging on your bedside, or that you can show someone if you truly don't want to be resuscitated. And so this form has to be gone over with your physician. You need to sit down and talk to your physician about this and about how you want to be kept alive if there is a resuscitation that is necessary. Or do you not want to be kept alive? And this will work in tandem with your healthcare power of attorney. So make sure that it doesn't say something different than what your healthcare power of attorney says. So if you said, I don't want life to be prolonged, but you check the box here that says full treatment, they're obviously not talking to each other, and now you've got confusion. So make sure that if you do one of these forms, that you provide it to your estate planning attorney so that there can be some coordination, okay? All right, so now let's pause for just a second because I was going to talk a little bit about Medi-Cal planning and special needs and things like that. But I'm just going to pause for just a second and ask if anyone has any questions about estate planning in general at this point. Yes, ma'am.
Yes. If I don't have children or any close relatives, or and I'm planning to leave a lot of my estate to the church,
Yes.
can I appoint somebody from the church to be my power of attorney?
Absolutely. So the question was, can I appoint someone from the church to be my agent under my power of attorney if I plan to leave most of my money to the church? And the answer is absolutely yes. You can name anyone that you trust on your documents in California, even if that person may have a conflict of interest. And when you think about it, children also have a conflict of interest, right? Because they could get an inheritance, and yet they're going to be named on those documents. You just might want to be careful about the health care power.
Yeah, that would be a different person.
That's a joke. That was a bad joke. That was very off color, very off color. So, no, absolutely. And our church is our family. And with a lot of people, our church is closer than our real family because we have shared beliefs and a shared history, and we understand each other intimately better in some respects than family. So absolutely you can do that. Again, you want to choose people who aren't in economic distress, who don't have bankruptcies, who have finances themselves so they won't be tempted to dip into the till, because these documents are private documents. And if you don't have family members to step up and say, hey, that was done inappropriately, then you have no safety net there if someone starts to take advantage. So you may have a situation where you do some special drafting in your document where you say, this person is going to be named as trustee, and they're going to give an accounting to this person so that we have some checks and balances here. And I tell you, that person who's the trustee will be very grateful of that because they don't want anyone to question what they did after the fact. For heaven's sakes, they want someone that they can report to because they're paying themselves trustees' fees. And, you might want to just define all of that very carefully in the document so that no one feels weird about it. And that way you could do that. But absolutely you can do that. If you have nobody and you also don't feel comfortable with individuals, no matter what you hear in the media about professional fiduciaries, I've worked with 25 professional fiduciaries my entire 30 years, and I have not one that has lacked integrity yet. Not one. Just salt of the earth, got into it for the right reasons, would be extremely protective and very strong advocates. So that's also a possibility, at least as backup. Because sometimes people get into doing a trust administration and they think, wow, this was supposed to self-administer. What are you saying? I have all these duties that I have to do, which we can also talk about that. But it's not easy being a trustee either. You have to have some investment smarts, you have to have some bookkeeping smarts, and you have to be a care manager because they may very well be watching out for you when you're going through an illness and making sure that you're properly protected and cared for, and working with your agent under your power of attorney for health care as well. So yeah, it's a lot to think about. Someone else have a, yes ma'am?
No, I'm confused. The trustee and the power of attorney, what's the difference in their roles? I know power of attorney is just for illness.
No, a power of attorney, an agent under the power of attorney and a trustee can actually be operating at the same time to manage assets. They're just managing different assets. So let's say you had a trust and you named Sue as your agent under the power of attorney and you named Barbara as your trustee. Barbara would be in charge of managing everything that you had added into your trust, that you had renamed in title as the trustee of your trust. So Barbara's managing that. And now Sue's coming along and saying, well, her income stream is going into this checking account. So she has this checking account that's outside the trust. All of her cars and her tangible property are outside the trust. I found a little savings account that's outside the trust. Her pension's outside the trust, and we have to sign tax returns. And I have to pay her daily bills from her assets that are outside the trust. That's really a typical scenario where people are signing checks from a checking account that's outside the terms of the trust. Because if you have a pension or if you have Social Security, they want to put it into an account that's just in your name. They're not always comfortable putting it into a trust name because it's your individual assets. And so it's kind of weird how that's split up. But that's kind of the split.
Well, who's managing all of that, the checking account?
So the person the agent under the power of attorney.
Oh, that's power of attorney.
That's power of attorney.
And what is the trustee?
They're managing all the trust assets.
Which?
So whatever you put in there. So if you put a home in there, and if you put a rental property in there, now this person over here, Barbara, is responsible for managing the rents that are coming in, making sure expenses are paid out, If there's a investment account of $500,000 sitting over there, now Barbara has to make sure that it's wisely invested. It's not going to lose money under her watch unless everybody loses money or whatever the situation is. So she's in charge of the trust assets. And you can pick and choose which assets stay out, which assets go in, but you have to do that quite thoughtfully, because if you had a $200,000 CD, for example, sitting out here in your own name, now it's going to require a probate over that asset to get it over into the trust because it exceeds $166,250. So that's, you want to avoid probate. You can't avoid probate by just creating a trust and letting it sit there. It has to have the assets in it
Specified.
for it to avoid probate. So it requires the creation of it and the proper funding of it in order to avoid probate. Does that make better sense?
The trust has to have that
Correct. Correct.
to avoid probate.
To avoid probate. So you don't want to have too much sitting out in your own individual name. Some, but not too much. Yes, ma'am?
Is there a ceiling on the amount that requires probate? I read somewhere that if it's under 1 million, there will be no probate required.
Yes, and I don't know where that comes from, but it must be a different state. You're probably listening to a national radio program, and there are states that only attach probate to the annual exclusion amount, you know, the estate tax amount. So at one point it was 600,000, and then it was 1 million, and then it was beyond that. And so
What is it now for California?
it's only $166,250. Yes, that's it. That's it. So most people who don't have a plan will be subjected to probate. And probates make attorneys very excited. They get to put money into their 401k. And they go, woohoo, probate. You don't want to make attorneys happy. No. You want to do planning that minimizes those fees and costs.
Thank you.
You're welcome.
But an attorney is the one that has to fill out all the work for you.
Yes, so you don't want to go to an attorney that says, you just need a simple will.
Oh.
Yeah, but not that anyone would be that unethical. However, there are people that are a little interesting.
Because you can
So-
get wills off of Zoom.com, LegalZoom.com.
Yes,
right?
which I would never recommend, by the way,
Why?
because most of the things that I have seen, that because they're not tailored to you and because there's no education process, often it becomes the $30,300 estate plan. Because somebody has to bring it to an attorney and straighten it all out after you've passed away, because it either hasn't been written appropriately or properly, or it's subjected to probate, or it wasn't funded properly, or a million other reasons. So it's always better to get proper advice about your situation. This is not an area where you really want to be penny wise and pound foolish. Not really. Yes, ma'am.
I see in your outline you were going to talk a little bit about the catastrophic care
Yes.
and Medi-Cal.
Yes.
Do you have time to do a little bit of that for us?
Yes, I was going to move on to that right
Oh,
now.
perfect.
Yeah.
All right, so no other basic estate planning questions. Oh, one more.
What's the obvious dilemma between making the person managing the trust and the power of attorney the same person?
You know, the only dilemma is that the person who is your power of attorney for financial matters is duty bound to watchdog the trustee. So if they're the same person and they decide to steal, then you don't have any checks and balances. But often there are people who have complete 100% integrity that they'll just put on both sides of the ledger because they know this is not a person that I have to worry about that with. Does that make sense?
It does.
Okay. Okay, so we're going to talk a little bit about Medi-Cal and catastrophic illness. Medi-Cal is a program by which the government pays for primarily long-term care. It will also pay for some of your care in the community, meaning living at home, but you have to be very, very impoverished presently for that to really come into play. So you either have to have less than $16,900 worth of income coming in the door, or double that for a couple, or you have to have $4,000 or less worth of countable assets to be living at home and receive Medi-Cal. So those programs are very limited at present. Just as a matter of interest, the governor did pass a new bill, which is going to be interesting if it actually takes effect. It's supposed to take effect in 2 years' time. And that program will allow people to use the same rules for Medi-Cal long-term care if they're at home and receiving what is long-term care coverage or care. So there's going to be an opening up of that. But right now, what we have is we have a situation where if someone needs convalescent care and they go into a convalescent setting, generally you're looking at somewhere between $8,000 and $12,000 a month. And it becomes private pay very quickly. So in other words, Medicare generally allows you only 20 to 100 days worth of coverage. And then one becomes no longer medically needy. They transition into custodial care, where there's something asserted by Medicare that your physical therapy has now plateaued, where you're being taken care of with activities of daily living like feeding, bathing, dressing. Those are the primary functions of your caregivers. And so you become custodial, and Medicare does not pay for custodial. Medicare only pays for medical needs. And so once you're categorized as custodial care, which happens a lot with memory loss and Alzheimer's and things like that, then your only recourse is private pay, long-term care insurance, or Medi-Cal. And if you are a single person, you have the same sorts of concerns, which is that your countable assets must be down to $2,000 as a single person before they will qualify you for the long-term care Medi-Cal. Now, there are assets that are exempt. If you are in a convalescent setting, your IRA, your 401k, if it's in payout status, is going to be completely exempt. One vehicle, your home, is going to be exempt. It's going to remain exempt. But if you try to rent it, the income stream is going to be able to go towards share of cost. So you want to think about that. But your home is exempt as long as you subjectively intend to return home. So this, again, need not be objectively possible, but as long as you say, or anyone in your family says, I have a subjective intent to return home, that home is going to remain exempt under present law. And so you can then be in a convalescent setting and you can qualify for Medi-Cal once you get the rest of your assets, which is basically your investments, your checking account, your savings account, down to the $2,000 limit. Now, if you try and give away that money, again, we'll be talking about a single person, you could potentially incur a period of ineligibility for making those gifts up to 30 months under present law again. And we're going to talk about how the law is changing, but under present law, up to 30 months. So say you gave away $300,000, you would not be able to apply for long-term Medi-Cal until your 31st month. You would have to wait that period of time. And what the law does is it creates a divisor, and it says, if you give away your assets for the average cost of nursing home care in California, which is little north of $10,000 now, we're going to divide all of the assets by that divisor, and for the period of time you could have paid for your own care, you're going to be ineligible. So if you gave away $20,000, you would be potential, and the average cost of care was $10,000 even, you would only be ineligible for 2 months. If you give away a lot more assets than that, you could be ineligible for up to 30 months. If you give away $1 million under current law, you're still only eligible up to 30 months because the look-back period in California is only 30 months. This is where you need to stay away from your national programs because this will confuse the heck out of you if you're listening to something nationally. Because in California, there's so much Medi-Cal planning that can be done that cannot be done anywhere else. Now, if we have time, I'll talk to you about that a little bit. But if you have a married couple, the spouse that's going into the nursing home can only have $2,000. But the other spouse that's staying in the community can have all of the exempt assets, including their own IRAs and 401ks, and can also have $130,380 right now, and qualify for Medi-Cal for this person. So a lot of what Medi-Cal planning attorneys do surrounds that planning process, because we have special rules that say if everything else aligns, we can ask the court to increase this amount that people can have to a lot. Sometimes I've increased it as much as $700,000 worth of assets or more, because the spouse that was staying at home has very little, if any, income. Sometimes we can increase the amount of income that can be kept. So the whole idea that I want you to walk away with is, if there is a spouse in convalescent care, you really need to talk to an elder law attorney, because there's a lot that can be done there, because we have very specific rules against spouses being impoverished in the codes and in the rules. The Deficit Reduction Act is going to be the law of the land someday. It was passed under the Bush administration in 2006. It was mandated that California accept it. We said, we're accepting it. And Arnold Schwarzenegger tried to make it the law of the land overnight by emergency legislation. It was rejected, and now we're going through a hearing process of all the stakeholders. And how many years later are we? At some point, if the Deficit Reduction Act ever comes into play, there will be a ceiling on the amount of home that one can keep. There will also be a dramatic change in the asset transfer strategies and the planning of that in general. But right now, we don't have anything on the horizon that brings in the Deficit Reduction Act. So
Does that mean that's a limitation?
it's going to be more limited, yes, if it ever becomes the law of the land in California. But California, again, allows us to do a lot of things that you're not allowed to do in another state. For example, we can transfer assets here. You may hear people tell other people, and this is another thing that you need to bear in mind, please, transfer your home right away because you might go into convalescent care. Please don't do that. Because number one, we took away the ability of Medi-Cal to recover against those homes. So that was most of the reason why everyone was panicking and running around and doing that, is because Medi-Cal could get paid back by the value of the home if you had to avail yourself of Medi-Cal. Since 2017, that is no longer the law of the land. Again, back to living trust, as long as you avoid probate. If you find yourself in probate, you are definitely going to be paying back Medi-Cal for everything, dollar for dollar usage. But if you can avoid probate, then you need not be transferring your home early. If you transfer your home early, it can be catastrophic from the standpoint that your donee is going to receive the basis in that property that you've had since the first day that you purchased that home. They turn around and subsequently sell it. They're going to be hammered with capital gains tax. Whereas if they wait to actually inherit the property, they're going to have little or no capital gains tax to potentially pay. So that's just one little reason of why you shouldn't be running around transferring your homes. So that's an area where you must see someone who has some expertise. There are only, you're wanting to look for a certified elder law attorney. Last time I looked, there were only 15 of us in Los Angeles County. So we are few and far between. So definitely find one of those individuals and sit down and talk to them. No, that's probably a lot, and I'm probably over time.
No, we have, I think, 7 minutes for.
Oh, okay, good. 7 minutes for questions. I could talk a little bit about special needs trusts. Would anyone like to hear about special needs trusts? When someone has someone that has limitations, you want to make sure that your trust addresses those limitations. Those limitations can take the form of a whole bunch of different things. You can have someone who has substance abuse problems. That's not a special needs arena, but that's a situation that a lot of people are now wrangling with their family members. So there are ways that we can draft those trusts to be more of a support trust, so the person doesn't just get a big chunk of money and then use it in a way that is detrimental to that person. If you have a spendthrift person who's just going to blow through the money in a matter of moments. By the way, if you look at the beginning of my materials, it talks about why charitable giving is a good thing. And it talks about the statistics on how fast it takes for your beneficiaries to blow through your money. It's rather shocking. It's rather shocking. So you can look at that. Yes, so it's very similar to people who win the lottery. Yeah, absolutely. So, yeah, that's on page 2, I believe. But, and then you may have someone who actually has a disability, someone who has an autistic child or a child with Prader-Willi or a child with all of these various different limitations where that child is actually receiving SSI and Medi-Cal. The last thing you want to do is give that person an inheritance that kicks them off of their needed benefits. So I do a lot of special needs planning, a lot of trust administration related to that as well. And it's a really wonderful area. So you want to definitely think through your beneficiaries and then the second layer of beneficiaries who could actually receive this. And what's the best way for that person to receive this money? Right.
Good to meet you.
Oh, lovely to meet you.
Thank you.
Yeah,
Thank you very
wonderful.
much. I so appreciate this. I come in front of all of you to say very directly, having worked with many, many, many people who have a sudden medical issue or who have a decline that seems very slow, but then they find themselves in a place where it's just impossible, or loved ones of people in those places. I don't care how old you are, or how healthy you are, or how much money you have or don't have. Now is the time to designate who your power of attorney is, whether they have health care oversight, whether they have fiduciary oversight now, because none of us knows what will happen when. Nobody. And the heartache, if you don't have somebody that you have named that you trust, and you find yourself in this vulnerable position, and somebody you don't know is suddenly put in charge, denial is not our friend. Please, please, get your papers signed ASAP for your own sake, as well as those who love you. Thank you so much.
Thank you. Thank you very much.
Oh,
Thank
and
you,
let me
everyone.
also say really quickly, if there's anyone here who does not feel that they have the financial wherewithal to have someone work with them to figure all this out, and you absolutely need an attorney, this is why we have a pastor's discretionary fund. There is no shame in seeking past year's discretionary fund
Well,
money.
how much does this generally cost? What's the cost of all of this, whatever?
Well, it does depend, but if you were to do, if you're single and you were to do an entire trust package with my office, assuming you don't have, something crazy like 10 properties and business and things like that, you're generally looking at between $2,000 and $2,500 for the entire package. If you're a married couple, you're generally looking at about $3,500 for the entire package. If you just need a power of attorney for financial matters, you're talking about $175 to do just the financial power of attorney or the healthcare power of attorney. And so each person is a little bit different. But again, if you're paying $2,500 to avoid $23,000 worth of probate expense
Oh, good heavens, yes.
and 2 years of dragging through the court system, sometimes it just makes sense, And
So
then we
at
also
very,
take
and forgive me
payments.
for this, at very least, do the power of attorney and power of healthcare.
Agreed.
And if you have any possibility of a trust, do the whole thing. Or if you have any other issues at all, do the whole thing, and we are here to help.
Yeah.
Thank you.
Thank you.